Welcome everyone to Nashua Community College. My name is Sally Bashalani. I am chair of the Arts, Humanities, Communications, and Design Department here at the college, but I also coordinate our efforts with our NCC lecture series. So this is part of our series for the academic year. And we're really happy to have everyone here this evening. Hope you were able to mix and mingle in the previous hour. What I would like to do now is just give a little bit of overview of why we're doing this. Those of you who may know that Sunshine Week actually is scheduled for next week, but we will be on spring break. So we figured nobody will be here. So we thought we would do the kickoff event this evening. And Sunshine Week is an annual nationwide celebration of access to public information. Not always easy to obtain, but it was launched by the American Society of News Editors in 2005 to discuss the importance of a transparent government. And so since then, events have been held nationwide in schools and through professional organizations. And tonight we have a mix of school and professional associations. As you may know, the Freedom of Information Act ensures the public's right to know. And this evening's panelists are quite familiar with right-to-know law for various purposes. So I did want to say, too, I think I'm a little bit late with this announcement. Pete had reminded me, but tonight's event is being recorded by Nashua ETV. So just wanted everybody to be aware of that. And so I will introduce the panel. We have one individual who will be here shortly, but those who are here, Gilles Bissonnette, he's the legal director from the ACLU, New Hampshire. Mark Doyle is the director of the New Hampshire Emergency Services and Communications and a former NCC criminal justice instructor. And I was just asking him earlier if he was maybe coming back to teach sometime, and needs to fit it in with his responsibilities up there. Mark is also former police chief of Merrimack, New Hampshire. And we have Dean Shalhoup, a veteran reporter at the Telegraph, 40 plus years?
47 and a half.
Wow, 3 more years, and
yeah, I know.
You'll get
I only
that
look
gold
47,
watch.
Right?
Dean started out at the Telegraph as a photographer, very young photographer, and he is currently the senior staff writer, and just has an extremely talented in writing.
Thank you.
Love reading his columns. And next to him is Nancy West. She is a longtime reporter as well. She is editor and founder of the New Hampshire Center for Public Interest Journalism. So, and then Rick Gagliuso will be with us shortly. He is an attorney, and he will be speaking from that perspective. He is very well versed in media law as well. So also present this evening, but not on the panel, is Justin Silverman. He's the executive director of the New England First Amendment Coalition. There he is, okay. And the coalition, along with the New Hampshire Center for Public Interest Journalism and NCC, are co-sponsoring this event. So thank you very much to those two organizations who are doing that. So each panelist, I'm going to ask each panelist to introduce him or herself and just give a little bit of an overview of their observation of right-to-know law and how it impacts them, how they use it in their area. Then we have some questions here that will be directed to panelists, followed by questions from the audience. So, if you would like to write down a question on an index card, maybe don't feel comfortable asking it yourself, but just get it to Tina, who's in the back there, and she'll probably be kind of floating around taking photos throughout the evening. So certainly do that, or, we'll take the live questions from you. So I think did I give my name? I can't remember if I gave my name, and I did, Tina. Okay, good, because sometimes I forget to do that, and I tell my public speaking class that's a no-no when you don't introduce yourself, when you assume everybody knows you. Yeah. Pardon? Oh, give it again. Sally Bashalani. Yes, from NCC. Yes. So, okay, Gilles, would you like to give a little bit more of an in-depth background than I gave, and how the right-to-know law impacts your work?
Sure. Thank you so much, Sally. Thank you so much to the other panelists here today. It's a pleasure to be here to kick off Sunshine Week officially. I could tell you that in my work, 91A, our right-to-know law, litigating those types of public record issues probably is constituting right now maybe 20% of my time. So it's a huge institutional commitment right now at the ACLU of New Hampshire on issues concerning government accountability and transparency. It's more really than it's ever been for the ACLU of New Hampshire. We've been focusing on a few issues with respect to the right-to-know law. The first issue that I want to talk about, and it's one that actually I'm working on a little bit with Rick, who's joining us right now, is an exemption called internal personnel practices. So I've been in this job now for about 7 years at the ACLU of New Hampshire, and I've started to see kind of some trends in the responses that I've been receiving from government agencies when I've been requesting various documents. And I started learning relatively quickly on this job that I'm getting some of the same exemptions back time after time. And the most common one was the internal personnel practices exemption. And I think quickly reached the conclusion in this job that it was really an exemption that is overused, one that's viewed very broadly by government agencies, and in my view is one that really is used often to hide information that's valuable, and that would be really in the public interest for disclosure. And in fact, oftentimes disclosing information where the privacy interests are minimal, where we're dealing with the official behavior of public officials, while they're working for us, paid by taxpayers. And so I started to notice this trend in some of the responses that we've been getting back. And then there was a Supreme Court decision from the New Hampshire Supreme Court back in 2016 that questioned whether that exemption was being applied appropriately by municipalities, and suggested, in fact, that maybe that's too broad, and maybe we need to revisit it. And what that case was really talking about was a decision from 1993 called the Fenneman decision, which basically said that the internal personnel practices exemption is a categorical exemption. It applies blanketly. So it doesn't matter if the information, there's a high public interest in disclosure. It doesn't matter if the privacy interest is minimal. If it's an internal personnel practice, categorically excluded. But this decision in 2016 basically said, well, maybe we need to look at that, because that's really potentially bad for government accountability and transparency. There should at least be some assessment as to whether or not the public interest in disclosure is high. What type of information are we really talking about when we're looking at internal personnel practices? What type of information is the government often withholding under this exemption? This is a case that Rick knows well, to my right. An arbitrator's report addressing a Portsmouth police officer who was terminated after receiving an inheritance in excess of $2 million from an elderly woman with dementia, withheld under the internal personnel practices doctrine. Obviously, a compelling governmental interest in disclosure, right? You can't, it's hard to imagine a document where there's more compelling governmental interest in disclosure. Nonetheless, withheld. That case is up at the Supreme Court right now. In addition, an internal audit report of the Salem Police Department that highlighted some very problematic cultural issues within that department and how the department failed to meaningfully conduct internal affairs investigations. ACLU submitted a public records request seeking that unredacted report. What did the ACLU get back? No, that's an internal personnel practice. Again, you're dealing with information, of course, where there's a huge public interest in disclosure. And of course, that report was funded by whom? Taxpayers. They're at a cost of approximately $77,000. Along with the Portsmouth case, that Salem case is at the Supreme Court, where the court is being asked now to look once again at that exemption and decide once and for all that that exemption really needs to be narrowed considerably so that we're really viewing Chapter 91A with that presumption in favor of disclosure, because that's really what 91A is all about. There are reasonable disputes between requesters like the ACLU and government agencies, but when there are these reasonable disputes, I think the law should favor transparency. That's the ACLU position, and I actually think a position that's reflected in the very text of Chapter 91A itself. Another example of information withheld under this exemption. Information from the Manchester Police Department concerning the termination of former police officer Darren Murphy. It was later disclosed that he was accused, not ultimately criminally charged, but accused of coercing women into sex. But this issue just really goes with, I should say, the union leader requested that information again withheld under this exemption. So yet another example. But I want to be really clear that this exemption doesn't just withhold information about police, though that's really, to be frank, been the focus of the ACLU's work recently. Relying on this very overbroad exemption, the Concord School District recently refused to disclose non-identifying portions of a September 2019 100-page report submitted to the Concord School Board, authored by an investigator hired to examine the district's response to complaints of inappropriate sexual behavior by a former teacher, withheld under this exemption. We have a lawsuit trying to get portions of that report that are not identifying, that don't identify students, trying to get portions of that report made available to the public. The public, again, paid for that report, paid for that investigator, and we think the accountability interests there are really so high. So I think it's important using those examples to really paint a picture that legitimate requests, important requests, are being rejected, where there really is, I think, a public need for transparency and accountability. But as I said before, there's hope. The Supreme Court's looking at this anew. 3 cases were argued, including the Portsmouth case and the Salem case, were argued at the state Supreme Court on November 20th, I believe, and we're awaiting a decision. So we may get good news from the court. We may not, and then we'll just have to reassess. It's really out of our hands. But there's been, I think, a really wonderful concerted effort between the ACLU and media outlets in the state, really collaboratively, to try to get this exemption looked at anew in order to ensure that our public records laws are viewed consistent with transparency and accountability.
Thank you. Okay, Attorney Rick Gagliuso of the Bernstein Shur Law Firm has joined us. And Rick, what we're doing is everyone on the panel is introducing him or herself and just giving a little bit of background as to how you deal with right to know in your legal profession.
Okay, thank you. Rick Gagliuso with Bernstein Shur in Manchester. Gilles just gave pretty much the remarks that I had in mind. So, because he and I have been working on this internal personnel practice stuff for quite a while together. He and I we should have talked because we're actually cousins-in-law, I think. Is it cousins-in-law? I think is what it means.
Rick's a good dancer on the wedding dance floor. So.
As of a wedding last fall. But here's my alternate remarks, and just a few minutes. I started out doing this, but despite the gray hair, I'm not really that old. But I did start out doing this work in the 1980s, representing the Telegraph mostly, here in Nashua. And at that time, the right to know law was not new, but still relatively new and still somewhat honored in the breach by public agencies. And we were just beginning to sort of hold their feet to the fire and try to open up not only records, but public proceedings, meetings and hearings and so forth. And I got involved in it with, thankfully, a very kind of enlightened ownership group and group of editors at the Telegraph who decided, you know, we really need to start to enforce this law that New Hampshire has. And I had a series of cases involving Nashua and Hudson and some of the surrounding towns and the state where we worked hard to try to enforce the actual literal terms of the right to know law. And the law was still in its infancy in terms of, you know, there were a lot of questions, a lot of open questions, a lot of things that the law didn't really address, a lot of ambiguities in the law, and of course it takes cases and cases and cases and people like Gilles to bring them in front of the courts so that they start getting interpreted and fleshed out. So throughout the 80s and into the 90s, it was something of a struggle to get agencies to pay attention to the right to know law and comply with it. And I remember telling editors at the Telegraph and other papers, you know, there's a great benefit from doing this that redounds not only to the particular issue you have in mind, but beyond. And it seemed to me that whenever we would take, for example, the city of Nashua or town of Hollis to task for not complying with the right to know law, not only did we generally get what we wanted, but it seemed to have an educational function. It seemed to sensitize them and let them know, gee, not only is there this law out there, but somebody's watching. Somebody's paying attention to how well it's enforced. And how well we're complying with it. And literally, you could see these agencies and cities and towns begin to pay more attention and begin to respect the law and the public's right to know. And conversely, if there was a period that went by where we weren't very active, you could almost see them relax and back off it. And then we'd have to sort of get active again and stand up. The 90s and into the 2000s were kind of the heyday, from my point of view, for the media enforcing the public's right to know, and for others, frankly, enforcing the public's right to know, because it's not just a media law. But in those days, newspapers actually were making money and had a little bit of money left over to pay people like me to go and fight these battles. Then, of course, what happens is, into the 2000s and beyond, tough times for newspapers. The internet takes over. You know, most of us who do this kind of work and call ourselves media lawyers sort of became internet lawyers overnight. You know, dealt with online issues as opposed to print issues. Because their revenues diminished and editorial staffs and newsrooms diminished in size, they just didn't have the resources to bring these cases. And there was a period of time, this is just my perspective, but there was a period of time where there really wasn't anybody in a position to take up these battles and enforce the right to know law. And a lot of us did work for pro bono, essentially, to make sure that there was somebody still speaking up. But it was tough times for a while. And now my sense, and Gilles, I don't know if you agree with this, but my sense is there's been kind of a resurgence. We've all managed to adjust to the new landscape, and we've all managed to sort of chip in to try to make sure these issues are given the importance they deserve. Some of it is because newspaper editors have dug deep and found some money to do it. Some of it is that people like me and Gilles and others have sort of said, you know what, we're going to help try to make this happen, and we're going to make it easy for you to do it if we can. Gilles, of course, from the ACLU, has had an enormous impact in the last several years on these cases. I think we've managed to get the legislature interested, and there have been a lot of very important legislative improvements, you might say, to the right to know law in recent years. There's a fellow named David Saad with an organization called Right to Know New Hampshire, who's been just phenomenal in paying attention to these issues, informing the public about them, informing legislators and lawmakers in cities and towns about them. And so I think times generally are pretty good for the right to know law right now. And in spite of the fact that newspapers don't have a lot of money to fight these battles, they seem to be getting fought, and we're making headway and a lot of progress. So my overview today is a little different from what I would have told you 10 years ago or more. The right to know law is pretty healthy today in New Hampshire, I think. We still have a ways to go. We still have some people to educate. But everybody that, for the most part, everybody that has positions of public trust in cities and towns and around the state, I think understand that there's a need for the public to know what they're doing. I'm not telling you that there aren't times when they try to find ways to skirt those obligations. Not telling you there aren't times when they do it successfully because there's nobody really in a position to do anything about it. But in general, my sense is that things have improved a lot. And believe me, I would have told you something different not that many years ago. So that's my overview today.
Okay. Thank you, Rick. Mark?
So my name is Mark Doyle. I currently work as the Director of the Department of Emergency Services and Emergency Communications at the Department of Safety. Before that, that's been my career for about the last 3 years. As Sally had mentioned, I'm a former adjunct faculty member here at Nashua Community College and currently serve on the Criminal Justice Advisory Board. My life prior to moving to the Department of Safety was that as a police officer and as a police chief for 32 years in the town of Merrimack. So when we talk about right to know and its evolution since the 80s, for example, it's come quite a long way. And I hear anecdotally stories, as Jill had referenced and as Jack had referenced, or Rick, excuse me, has referenced, about municipalities or towns or governments going in different directions and what their interpretation of the right to know law would be and what their requirements are under the guidelines of the framework of RSA 91A. And I think they would agree, too, that there are some that are far more, I don't want to say cooperative, but more engaging.
I use the word enlightened.
Enlightened. A lot of it has to do, at least in my respect, a lot of it has to do with an understanding and an education, as Rick had alluded to, when it comes to what the knowledge is out there and what the education is out there from government employees, those that are in the world of being entrusted with the public safety and welfare, such as police officers, and their chiefs, and those decision makers who have to make decisions about what information they can release or should release contemporaneous to and which is required under the framework of RSA 91A. And I think that's kind of where the interpretation starts to either break down or bolster itself, or where camps become divided a little bit. Again, it's dependent upon which attorneys are working in which groups and whether they're getting information from the Attorney General's office or following the direction from their local or municipal attorneys. So what they try to do, at least in my respect, and I can speak from my own experiences, when we get a 91A request, we ask a couple of questions very simply and right out of the gate. Number one, we want to make sure that we're compliant, so we try to stay within the framework of the law, meaning we have to adhere to specific deadlines and timelines associated with releasing that information and providing a status on where that information is in terms of our research, whether the information even exists or not, and whether it's actually compliant in terms of being a governmental record. When we talk about personnel files, for example, that's still, I don't want to say a touchy situation, but it's still really up in the air when it comes to what can or could be released and whether it has to be done, if it's if it's a lorry situation, and we probably will delve into that a little bit later on, whether that information can actually be released to the public or has to be viewed in limine or in a governor's, or in a judge's chambers, for example, to make sure that that information that's being provided to a defense attorney based upon that right to know request for an appropriate defense of a criminal case. And there's a lot more involved in it than what I'm just talking about. However, those kinds of things do change because, as we had heard, it's a dynamic field and it's not set in stone. It continually changes. There are bills in front of the state legislature right now that talk about changes and amendments to the right to know law. What I've always tried to do from a government perspective is make sure we're as transparent and as forthcoming as we possibly can with the information that you, as our citizens, need because you need it and because you want it. No other reason why. There's no reason for us to hold on to it but for some of those exceptions. And if it means we have to hold on to it to make sure we're safeguarding the public trust, or we needed to do it because release of that information may otherwise jeopardize an ongoing investigation, for example, or release information that we don't want out there quite yet because it's not verifiable, because there's more information that has to be obtained from the government to provide to you, your citizens, then that's what we need to do. And again, we follow the direction of our own legal minds when it comes to releasing that information or providing that information to those who request it. It's all about transparency, as you heard, and I think we all agree, and I don't think that's going to change on the panel, about transparency and what government's role is in providing a safe and engendering environment for all of our citizens and looking out for the safety of everybody when it comes to education availability, when it comes to services in terms of the public services that government provides and the like. I think what happens is it gets a little mired down sometimes in the definition of what is releasable, what is confidential, what is protected. And again, that's why we have jurists to be able to make those kinds of high-level decisions and then provide us in government a little bit better direction on what should or can be released. One of the bigger challenges I already alluded to is the ever-changing dynamic of what is happening to address the needs of the citizenry as they change and evolve, and where the legislature is moving in terms of making amendments to or changes to the current law and statutes so that that information and those changes can be passed down to local governments, city governments, town governments, and even at the state level, so that we can remain compliant with what those dictates are. It's not about us trying to hold back and prevent you, the citizens, from getting any information that you are entitled to have. It's just a matter of us trying to make sure we're dotting our I's and crossing our T's to protect people's privacy rights in addition to being as transparent as possible.
Okay, thank you. Dean?
Greetings, everybody. Excuse me. As Sally said, I've been at the Telegraph for quite some time, and I was not there, however, when the state of New Hampshire passed its first right to know law. That would have been late August in 1967. And what I was doing then was following the Red Sox in that great 67 season. I think so a lot of people might have missed that story.
I was 6 years old.
I was a little bit older, but certainly not employable yet. I referred to that in a column I wrote that appeared in Sunday's paper. I mentioned John Bednar, who was a state rep and held several other offices in the town of Hudson for many years. And he was a character in a lot of respects, but he was truly a champion of it. He applied himself and got allies on board and was a guiding force, I think, to get that legislation passed. In my early days at the Telegraph, we weren't so focused on right to know. I don't think I even knew exactly what it meant when I was hired as a 18-year-old cub reporter and everything back at that time. But as time went on, like Rick alluded to, being, I don't know if it was the 80s, right, when you joined the Telegraph as our attorney, that's when
I
things
think I started getting you out of trouble, Dean, shortly after I passed the bar.
Rick did save me a couple times.
Me too.
And I don't know if it was pro bono or not, but I think it was worth it to the Telegraph. But at any rate, but that's when I came into, and people began learning a lot more about it, both in the newspaper world and other news outlets, as well as in government and just the average member of the public. I don't know how many times somebody's asked me, how do you get that information? Do you have a special pass, or are you on a special list to go down to City Hall or to the courthouse to get this information, see a particular file, for instance? I said, no, I'm just a guy who happens to work for the media. Anybody can go. I try to explain to these people to those locations and see, with some reasonable limits, of course, juvenile cases and what have you, but people are starting to learn that more and more. There was a few bills that were proposed for this legislative term that I didn't refer to in that column, but we had a list of them. There were a couple of them that seemed to try to restrict news organizations and the public, more importantly, to seek public access to documents, minutes and records available for public inspection. Most of these, if not all of them, were either tabled or aren't alive anymore, to the best of my knowledge. But just, the idea, an attempt to discourage, it would seem to discourage, would be right-to-know seekers when they allow the agency to put a fee on looking or providing information that the public wants to look at. Somebody who's, in a people of means probably have no problem doing that. But people without means, they'd be probably blocked from being able to do that because they can't really afford it. Reasonably described is in another one. Means a document that is identified with necessary specificity. Well, it should be. You can't just go in there and say, I want this document, everything that had to do with him or her forever. There should be parameters, and there are. To tighten those a little bit more, it probably isn't necessary. I think that I'm of the thought that between the fees and the job of locating records, again, within reason, is part of the individual clerk's jobs, and that's where it falls. And if it gets really busy because there's a lot of right-to-know requests or other business, they might want to consider hiring another individual. That's easier said than done, of course, but that would be a good way, to handle it. Liability in news media was a very disturbing one, and we were glad to see it go away. It might seem reasonable on the surface, but it's practically almost impossible. The gist of it, for those who aren't familiar, would penalize and open to possible litigation news media that does not follow up, see through a case, a criminal case, to the end and report on the outcome of it. Now, on the surface, that might not seem like a bad idea. It seems fair, right? Well, you covered the arrest, why don't you cover the trial? Well, if it's a big enough case as a trial, it would be covered in most all cases. However, to put it in a position where news media is forced to follow up something that may be just a minor matter, probably certainly isn't the best use of their time. We at the Telegraph, and I personally agree that following up stories whenever possible, which I try to make sure it's done on anything that's significant. I don't want somebody's, a story about somebody's arrest and a mugshot in the paper and then no word, and the accusations, of course, the charges, and then no word of what happened to them. If we've gotten email requests from people or calls from people who were found not guilty or the charges were dropped, and I double check it at the courthouse, and sure enough, if they are, I'll update the website, the story on the website to say that. Same with in the paper itself, especially if it's a significant enough case, I'll write a little story saying so-and-so who was arrested, the charges were dropped. So I think it's an important thing to do, but putting a situation, make it a situation where we could be held liable, I don't think is the way to go. Where this one came from, I don't know, but it was the release of mass murder information. It prohibits law enforcement in the state from releasing the name, age, or image, rather, not age, but image, photo, or other information about a mass murder suspect unless the Attorney General determines that withholding such information poses a threat to public safety. Mass murder means an incident in which one or more persons kills or attempts to kill 4 or more people. Well, geez, I hope it never comes to that, one way or the other. But those are just some of the examples of legislation from our standpoint. Certainly, we just assume not see pass because we feel, and I think it's pretty obvious, it would restrict the ability to fully utilize the right to know law. Again, not so much for journalists, but for the public. That's the first, our first concern. And that's why we do what we do and try our best to do it fairly.
Okay, thank you. And Nancy?
Hi, I'm Nancy West, and about 5 years ago, I founded the New Hampshire Center for Public Interest Journalism, and we publish online the state's only nonprofit news website. We refresh it daily. We are a very small outfit, but we do a gigantic, fabulous job, if I do say so ourselves. And where to start? It's wonderful to be here because on this panel you have the best and the brightest of people who are really passionate about the public's right to know and want to get the appropriate information out. So I think I'll start a little bit. 91A only covers, it does not cover certain things. If I want to get a public record or attend a public meeting, that's one thing. I can't make public officials talk when I want to. I mean, I really wish I could, because that's where a lot of the answers are. If a public official or a department, a governmental agency, does not keep the document that I want to read or pass on to the public, they do not have to compile it. That's one of the downsides of the right to know law, in my opinion. Because I've been turned down any number of times because an agency might say, we don't keep that data in that information, in that form that you are requesting. And I don't get it. It is a great time for the right to know law right now because we do have great people, Gilles Bissonnette with ACLU New Hampshire, and Rick Gagliuso, who happens to also sit on the board of directors for the New Hampshire Center for Public Interest Journalism, have been really great. We've got a number of cases that are being argued in court that will help all news media in the state obtain the information that you're entitled to. This isn't so newspapers can write a story. This is so we can report to you what's going on with your public officials. These are your public records, just like mine. You know, these are my records. I'm probably remember most is paying attention in problems of democracy class. I mean, I believe that stuff of government of the people, by the people, for the people. Whenever the government creates a document, I'm probably a little more radical than some people, but whenever the government creates a document, I believe it is a public record unless there is a real exemption and a real legitimate reason why it isn't public. So I always start from there, and I think that's where a lot of the court cases start as well. And I can tell you a little bit because I've been around a long time, that the whole atmosphere around the right to know law has changed in the 30-plus years I've been reporting. I was probably almost 30 years at the Union Leader in Manchester, and between the Union Leader and the Nashua Telegraph and the Keene Sentinel, those are the three newspapers who really created the most case law about the right to know law by challenging different entities in Supreme Court in New Hampshire. And as Rick was saying, as money dried up, it became harder and harder for newspapers to have a staff attorney that could handle not only different right-to-know requests, but also to deal with reporters if there was maybe a particularly sensitive story that, I can remember many times dealing with, our attorney was Greg Sullivan over the years at the Union Leader, dealing with him about stories to make sure we were 100% fair, to make sure we were covering our legal butt and doing what we should be doing as reporters. And luckily, Gilles and Rick have taken up the mantle, and Greg, I think also, Greg Sullivan is doing some work too, to get these cases before the Supreme Court. That's a very expensive task. First, let's say I'm turned down for a public records request. The only alternative I have after that is to file a public records suit in Superior Court. Now, I've only filed one since I've started indepthnh.org because it's expensive and it went nowhere because I couldn't afford to keep it going. That's not counting the ones that Rick Gagliuso has worked pro bono for me, for which I'm very grateful. But it's $280 to make that initial filing. And that doesn't count the money you have to pay to have it distributed by the different sheriff's department to the people that you name in the lawsuit. So things have changed. When I first started out 30 years ago, I would call up a department head or whoever was in charge of their information and say, I'd like to know this, that, or the other. And they'd say, fine, I think I know how to get you that information, and I'd usually have it by the end of the day. And that the right to know law was in effect then, but it wasn't required to do with every single request as you went. If I wanted to look up an old homicide case to see what the files showed, if I had a new tip on solving the case or whatever, I'd call the Attorney General's office. They'd say, you know what, it's going to take us 3 days to get the boxes down from archives. And they'd bring down the boxes that had all the evidence, all the police reports, the bloody jacket the guy was wearing the night he was murdered, all sorts of different things were in these boxes. And I'd go up and go through the boxes. It was just a wonderful adventure. There were also records that were in sealed envelopes. And they would say, those are sealed, don't open them. And of course, I didn't open them. And there was a lot of trust between government agencies and the reporters at that time. Probably about 15 years ago, I'd ask a question and people say, yeah, do you mind putting that as a right to know request? And I'd write up the 91A. If you ever want to look up how to do a 91A, call me. It's wicked easy. And important that we do that. It's important that we keep holding people's feet to the fire. Feet, no, it's not plural. Feet to the fire. And I love it when citizens want to do that. On David Saad's website, RTK New Hampshire, Right to Know New Hampshire, we have a link to it on indepthnh.org. There's a step-by-step guide of how to file these and what to expect when you do file them. So then about 15 years ago, that was more of a courtesy. And by law, agencies in New Hampshire have 5 days to respond to your request. Well, instead of turning over the information within 5 days, what I found over time was I'd get my 5-day letter, and the 5-day letter would say, it's going to take us at least 3 more months to put that together. We don't have enough, they didn't put this in the mail, but perhaps the reasoning would be there was not enough staff to do this. In my opinion, state agencies have enough money to enforce every other law in the state of New Hampshire. I think they should be funded well enough so that they can enforce the right to know law adequately and do a much better, quicker job. I have a CD waiting for me at the Attorney General's office that I've got to pick up tomorrow, that this is information I requested, probably 8 months ago. And I understand they're troubled for time, but by the time I get the information, the story's moved on often, and I have actually picked up documents, and I couldn't remember what I wanted because it had taken so long to get that information. So I see things as kind of coming full swing. I think there was a real attempt years ago, 30 years ago. If I call the Attorney General's office, they actually had a staff attorney who was in charge of helping people like me get what they needed. And that person would maybe make a call to a local municipality who didn't realize that they were covered under the right to know law, that they were supposed to be releasing it. So I think things have kind of come full circle, but now because of the lawsuits that are being filed in both Superior Court and up to the Supreme Court, I think people are starting to get interested again. What happened along the way, besides the fact that newspapers didn't have a lot of money to pay for legal challenges, we also lost 60% of all news jobs in New Hampshire just disappeared between 2000 and today. 60%, maybe that's not all reporters, that could be darkroom personnel, that could be plate makers, other people, but newspapers are at their weakest in 2 decades, and yet they are fighting very strongly. And that's one of the reasons why indepthnh.org got started. We want to buoy all the other newspapers. We want to see, I'd love to see us put ourselves out of business. I know that sounds crazy, but we're not going to go out of business till we have a vibrant, healthy news world in New Hampshire. I belong to an organization called the Institute for Nonprofit News. I sit on the board of directors for that. Our mission in the next, I think it's 10 years, is to put 20,000 more reporters back on the street. We have lost so many reporters over the years. And one thing I just like to stress when I'm talking about public documents, we're not just trying to sell newspapers or, of course, that would be nice, and we encourage you to buy newspapers so we can afford more reporters, more legal battles, more fights for your right to know. I always suggest people buy a subscription. I know it's a great time to complain about our local news and about what we're doing. We're doing the very best we can, and we need your help. I love it when people like you show up because I know you're interested in what is the future of news? How are we gonna get there? I think the Washington Post has a good motto. It's democracy dies in darkness. If you wonder why we matter, or if I ever wonder why we matter, it's because we're part of that whole principle of an informed electorate. We need to keep people informed. I was at Dunkin' Donuts trying to file a story last night, because we're mobile. We file anywhere. And there was a gentleman speaking there to his friend. Actually, they were fighting. I had to move. They were fighting because they were disagreeing on who was lying the most about COVID-19, and how this was just a big way to get money for businesses, so papers are just overplaying it. And I can tell you, from our perspective, and now that we're a nonprofit news outlet, we probably don't do much crime anymore. Report on it. We never did a whole lot of it, but we don't report on it too much anymore. But oh, I lost my train of thought. Oh, this happens to me a lot. And, COVID. So anyway, we had, you know what we need to feel, we're responsible. I was talking to, I heard a rumor yesterday that one of the COVID-19 patients had gone through Elliott Hospital's emergency room. Now, that's important, and it wasn't reported anywhere, and the state wasn't reporting it. They're bound by a whole separate federal law called HIPAA law, privacy laws that I won't get into right now if you want to do it later. But, so I called the hospital up and they said, this is a good learning experience, and I spoke with the chief nurse who said, yes, the person came in, but they did all the right things. They called first their primary care doctor, then they came in without surprising anybody. The staff from the hospital wearing protective gear met the guy in his car and ushered him into the back room or the back door of the emergency room at the Elliott and did the appropriate tests. The gentleman was wearing the right mask and everything. And it's important because the rumor was out there that they had people in the back of the emergency room all dressed in protective gear. People were afraid, maybe only a small number, but that kind of rumor spreads quickly. So by doing that story and getting it out there factually, saying this was done safely, this is what has to be done, and you don't leave people out in the woods because they have symptoms of the virus. So our job is to get as much information to the public as possible. I've never seen myself, I think today maybe you have more celebrity journalists, but I didn't come from that era. Too bad. But what we really need to do is make sure people have enough information to keep themselves safe from this virus. I don't feel we're overblowing it by discussing how to, what the state officials or the nurse at the hospital or whatever is doing. If you want to talk more about HIPAA later, we'll go there because that's a whole horse of a different color.
Yeah, we have a question about that and COVID, so yeah, we can get to that.
So
at
I'm
some
just
point.
glad you're here. Thanks.
Yeah. All right, thank you. Dean, Nancy touched upon this a little bit. Do you find in your career that obtaining records from the government has become easier or more difficult over the last 3 decades? And, what has or has not changed in your perspective?
If I had to say one or the other, yeah, I think it's easier. It's become easier in more recent times, over, you could say over that 30-year span, mainly because we as journalists, or I'll speak for myself, know more about how to go about it. We learn more about how to go about it, and have more success as a result of that. Along with that, I think it became more formal. In other words, writing up a request, we all, like Nancy said, we all have templates, in a folder somewhere on our desktops that you just, the language pretty much remains the same. You change the basic numbers and info and who it's going to. So I think it's streamlined a little bit. The only exception, I think, would be is if an entity isn't familiar enough, or the public entity, whoever works there, isn't aware or familiar with how the process works, that would bog it down, certainly. Then you find yourself chasing around who may. And sometimes, especially in smaller communities, it might get to the point where they'll try to send you around in a circle till you just give up, unfortunately. That's become rarer, which would go to my earlier comment that while that's become rarer, it's become easier for us to obtain those records, mainly because of the formal approach.
Okay, thank you. So, Mark, you're head of a state agency. What does the government have to worry about when considering information to release to the press and the public?
Yeah, thanks. That's a great question. And the government has to be mindful of, number one, what the request is, to make sure that we either have the information or don't. We're communicating that to the individual who is requesting it, and letting those folks know who are requesting it, just those things, whether we do have it, whether we can get it, and whether they can get it within the allotted time frame that the statute requires us to produce it for. And if not, we have to message out exactly when we think we'll be able to provide that information. So it's very, as Dean had alluded to, it's very process-driven. And we want to make sure that we're, from the process side of things, we're compliant with the guardrails established by the statute, first. Secondly, the information then has to be looked at to make sure that any information that we're divulging is exactly what the individual has requested, and whether there's any other information in there that has to be redacted out that's not compliant with the request or can't be disclosed because of its confidential nature. And that falls under a number of different categories. It could be due to an active ongoing investigation. It could be a personnel-related matter that we already had Gilles and Rick speak a little bit to. And if and when those kinds of issues do perk up, we make sure we get some clear direction from our legal team to make sure that we're actually falling within the guardrails. It's very process-driven, as you would have heard before. It's not something that we can just go to a file cabinet, pull open a file, make a bunch of photocopies, stick it back in an envelope, and then put somebody's name on it and say, hey, it's available, you can pick it up at the end of the day. It has evolved quite a bit from those days when we were able to do that kind of thing. We want to make sure that we're as transparent as possible, that government is as open as possible. However, we still do have certain responsibilities to people and their privacy interests when it comes to releasing information that might have some personally identifiable information in there that should not be disclosed as a result of a right-to-know request.
Okay, thank you. I think this question can go to Rick and Gilles. More cases regarding government records seem to be flooding the courts today. Is this true? Are you finding that this is true, and if so, why?
So, I don't know if flooding is the right term. I can say that we have, I think, either 5 or 6 cases, and maybe our communications team is doing such an effective job at the ACLU in New Hampshire to get those cases out, to seem like we are flooding the courts with 91 validity.
The PR people are doing a great
Exactly,
job.
doing a brilliant job. I mean, I can tell you certainly from an ACLU perspective, it's part of a coordinated campaign. I mean, we made a dedicated commitment maybe 3 or 4 years ago to just focus on this issue, to strategically choose cases that really presented the best set of facts and presented a really strong, compelling governmental interest in or public interest in disclosure, to then get these legal issues before the court with the hope that with good facts, with a strong, compelling governmental interest, we were able to reshape the law in a way that's just more transparent and more consistent with the presumption of disclosure that's embedded within Chapter 91A. So it's done strategically. Choosing the right cases, choosing the right facts, choosing the right documents we want to fight over, and whether it's the so-called Lori list, whether it's a Salem police audit or the Concord School District Journal audit. That's why we're doing those cases, because they're just really strong cases factually to show really how this exemption is being applied on the grounds. And I think we've also been trying to use those cases to do public education, not only with the public, but with government officials as well. I mean, it's true that there's a lot of exemptions under 91A, far more than I would like, to be honest, which probably comes as no surprise from someone in my position. But I think it's important to note, too, that even if something may be exempt from disclosure under Chapter 91A, that actually doesn't mean the government can't release it. the government can release information that may fit one of these particular exemptions. This is another way to say it. It doesn't create a privilege. It doesn't require, if something is exempt, it doesn't require the government to withhold it. And so we've been trying to do some advocacy on that point as well. And I'll leave it to Rick to finish
Yeah,
up.
I wouldn't say at all that there's a flood of right-to-know cases in the courts. I would love it if there were 10 times more cases in the courts. We just don't have the resources to do it. I agree with Gilles that, those of us that do this kind of work try to choose our battles a little bit, and we're sensitive to not making bad law if we can help it. So we try to be judicious in the cases we bring. But in general, the system would benefit from more and more people enforcing the right-to-know law, and we just don't have the resources. One of the deterrents, I'm going to take this opportunity to point out what I think is a huge flaw in the right-to-know laws that exist today, and advocate for a change. Under New Hampshire's right-to-know law right now, if you prevail in a suit to uncover records or to get access to a meeting, you are not entitled to recover attorney's fees, even if you win, unless you can show that the agency involved knew or should have known that what they were doing was in violation of the law. In other words, you have to show that there was kind of a knowing violation on the part of the board or agency you're talking about. That's a really high hurdle to get over. And most judges, in my experience, tend not to find, even if they find that you're entitled to a record, they tend not to find that the agency involved sort of intentionally and knowingly withheld it. And so they don't award attorney's fees. That means it's your nickel most of the time when you file these lawsuits. I wish that the law were different. I wish that if you prevail in a suit under the right-to-know law, you were entitled to recover attorney's fees, because frankly, you are at that point advocating for the public's interest in public proceedings and public records, and it's the public that ought to pay. And so the agency, in my view, should reimburse you for the expense of bringing that lawsuit and legal fees and costs and so forth. Because between you, the party that brought the suit, and the agency is the one that ought to be paying for it. That's not the way the law reads right now. And so there is in my view, a deterrent built into the right-to-know law to bring lawsuits that I think needs to change.
Can I add to that? Because I totally agree with what Rick just said. And to me, that would be such a huge beneficial change to the right-to-know law if we had mandatory fee shifting. If you bring a lawsuit and you're successful, you get fees. And it's not just for all the reasons Rick said. An additional reason is when that's in the back of the mind of a government agency, they are more likely to, given some of the ambiguities in our right-to-know law, they are more likely to make a decision in favor of disclosure. And that is consistent with what the statute is really all about in general, is the presumption in favor of disclosure. The default is I should be giving it to you, right? And so that's why I actually think if we were to make that change, it would actually be incredibly more beneficial and create really a more transparent New Hampshire. And I do want to reiterate once again just how many ambiguities are embedded within the statute, and that really give government agencies a lot of opportunities to withhold documents. So a good example, my favorite, the exemptions that I deal with a lot, my least favorite exemption, 91A5 Roman numeral 4, right? Ton of exemptions listed within that, including the internal personnel practice. I'm not going to get into that. Another exemption, something that's confidential, also personnel file exemption, not to be confused with internal personnel practices. That's a whole other issue. What the hell does those terms mean? The courts have interpreted both of those exemptions, personnel file and confidential, to mean if something can be viewed as confidential, that's not the end of the analysis. There still needs to be a balancing test of the public interest in disclosure and the privacy interest in disclosure. Who is doing that balancing of the government agency. It's, a person making a decision. And sometimes that government official is actually doing a good job in going through that assessment, but oftentimes that's not the case. And, that's just a confidential document, and if the courts have to figure it out, the courts have to figure it out. I would submit that that's not the right approach, right? The right approach there is, well, I see the governmental interest, maybe there's some privacy interests, but on balance, the public interest should prevail. I'm going to disclose it. That is viewing the statute consistent with the presumption in favor of disclosure, but I only want to highlight that to really demonstrate that some of these things are loosey-goosey, all the more reason, I think, for the legislature, hopefully down the line, to accept Rick's suggestion to at least create some fee shifting to provide some really good incentives to allow us to get more.
Yeah, I'd like to just weigh in on that as well. Of course, I agree with Rick and Gilles that if we were able to get attorney's fees when we won a case, that would be a great deterrent in the future for agencies to withhold documents. I hear a lot of people saying, we do not have the staff who is trained to understand the right to know law. It's not rocket science, and I don't see a lot of those same agencies offering training, taking it seriously. If that agency had to pay legal fees, and they can be substantial by the time you get through Superior Court and the Supreme Court, I think that the money would be better spent training people in the different agencies. What is the public's right to know? And I also hear a lot about privacy, and I hope we'll get onto this issue in a bit. People say, well, we have to guard people's privacy. Well, there are ways to do that in the court to balance someone's right to privacy versus the public's right to know. And I believe the public's right to know usually trumps that unless there's something that's really overriding. Perhaps it's a health issue, perhaps some sort of personal matter like that. But I hear that a lot, and there's also a shift in privacy rights of victims. I hear more and more different organizations want to protect the privacy of victims. Now, in New Hampshire, we've never published the name, I don't know about never, but not in my time, have we ever published the names of sexual assault victims or alleged even before they're gone to trial. And I see that as extending. Now, I know there was one organization that took issue with my reporting and some other reporting on a case that involved misdemeanor domestic violence charges, not sexual assault. They thought that name should be kept private. In fact, the Attorney General's office agreed. When the Attorney General's office issued the news release about this particular case, it was about a state senator who was arrested for 9 misdemeanor, not sexual assault, 9 misdemeanor domestic violence charges. The Attorney General's office never named the alleged victim, even though the alleged victim was a public official who was also running for office, was the fiancé of this particular state senator. Actually, that trial's going to start next week. That should be kind of an interesting one. But the only reason indepthnh.org got involved in that particular case was I couldn't figure out why the newspapers weren't naming the alleged victim. We had never kept that confidential before on a domestic violence case, although, to be fair, there's not a lot that rise to the level of making the news. A lot of them are just horrible family issues that go through district court that don't make the newspapers. But I see, in talking with people from those organizations, I know they'd like to have a lot of victims suddenly disappear and become confidential, and I try to remind them, this was taught to me by a lawyer, and I've had the benefit of many great lawyers over the years, teaching me a few tricks of the trade here and there. But the victim does not bring criminal charges. It's the state that brings the criminal charges on behalf of that victim. So, and these are all state resources being spent on the investigation, the trial, if the person goes to jail, paying for keeping him or her locked up. And we just go down a very slippery slope if we just start making, okay, well, we think because it's kind of embarrassing to be a domestic violence victim, we got to shut that down. We can't put that in the paper anymore. It's just wrong. It's just, there's no reason for it except that victims are gaining tons of rights in the court system, and I think that's mostly really terrific. Victims today, years ago, victims never had the right to speak to the judge before sentencing. Victims have a lot of rights they've deserved all along. I'm really in favor of victims' rights. But when you're spending public resources on an investigation and a trial, et cetera, these are unfortunately public information. And I've heard victims or alleged victims or victims say, I'll be shamed, I'll be this, that, or the other. And I hope we're not there as a society, that because somebody's involved with a domestic violence situation, that they're somehow going to be shamed at work. I'm sure there's certain people that'll shame anybody. What the heck? But I think we've evolved a little bit beyond that, and I'm glad. I've been really in favor of victims' rights since before. I remember years ago we did stories about different police departments who wouldn't arrest anybody for domestic violence. They'd walk the husband around the block or whoever, usually the husband, and then send them back to the victim. And things have changed. Why? Because of reporting. I remember Norma Love did a terrific piece for Associated Press one time that showed a domestic violence victim with a black eye, and the judge had made some very coarse remark about, that kind of implied she deserved it. And papers ran that on the front page. Things changed. Information helps society evolve. It covering things up. Helping people know less. It's very frightening in a world where we need more information, we need more facts, we have too much fake news. It's time to tell the truth. I've always found as a reporter, if I just try to stick with telling the truth, I won't get in trouble. And I'm not a particularly moral person, but I'm the kind of person who gets caught, so I try to just do the right thing, so I won't get in trouble. And anyway, enough for me.
Can I chime in on that? I'm sorry.
No, Mark wanted
wants
to
to respond.
respond
Yeah,
to what Rick and Gilles had mentioned, I think.
I just wanted to address a couple of
Sure.
the items that had been discussed just recently. And one thing I want to make sure is that let's not paint government across the board with a broad brush, and let's not just apply anecdotally what has happened in a few of these cases that we've heard about across the board. I can tell you this, though, and I'm not going to talk about attorney's fees. I think that's a discussion for another day. What I am going to say this about that, though, is this, if that makes sense. When we are in a position where we have to make decisions about ambiguities in the law, which I heard across the board, it becomes difficult for us to make those decisions in a vacuum. And we can't. It'd be irresponsible on government's perspective or in government to make irresponsible decisions regarding requests that our citizens make of us. If we're going to make decisions, we have to do so by making sure we're doing it the right way. And we err on the side of caution. It's in our nature. And we will withhold information at the risk of being called out on it because we don't want to divulge information that may be of a private interest to somebody else that's referenced in a particular report or other item that you're looking for in terms of your request. The important thing to remember is this, though, because government will get called on the carpet. We'll be subject to the civil lawsuits. We'll be subject to the potential criminal violations if we disclose certain information. That's why we err on the side of caution. It's not because we want to do any dancing around the law, don't want to comply with the law. As you heard across the board, and I'm the first one to agree with, there were a lot of ambiguities in the law. A lot of it is up for interpretation. And what one judge decides in the Nashua Superior Court is going to be completely different from what a judge decides up in Superior Court up in Boscawen.
It's completely different. It's based upon interpretation of the law, which can change. It's up to all of us to make sure that we hold our legislators' feet to the fire, to make sure that some of those ambiguities are cleared up. But law is an evolving, living entity. It changes. It changes because people are involved in it, and decisions are made that affect the decisions as they move forward, whether it's at the Supreme Court level or otherwise. I mean, we've got to be mindful of that. Nobody wants to make it more difficult for people. I'm going to speak for myself. Make it more difficult for people to get the information that they're looking for from a government entity or government agency. We all try to be as compliant as we can. At the Department of Safety, we have a staff of legal lawyers and paralegals that work diligently on almost all of this all day long, and they are backed up to the hilt with trying to make sure that they're compliant with what it is that the law requires them to do and what's being requested of you to provide to them. We don't want to make any mistakes, God forbid. We want to make sure that we're compliant with the law because the law says this is what we have to do. We also want to make sure that we're balancing that with the privacy interests of those who may have information in that report or that material that the citizens are requesting. And yeah, we're going to err on the side of caution, not because we want to make it more difficult for you as a citizen to get that information or make lawyers jump through hoops. It's not what we want to do at all. We want to do it because we have a responsibility to our citizens.
Yeah, I want to echo actually something Mark said. I hope Mark doesn't feel like I'm piling on, or we all are, because I want to echo how difficult I actually think the job is of someone who gets some of these requests. I mean, we're talking about documents that are complicated, that are multifaceted, that require redactions. I'm very sympathetic to the idea that these things take time, that there's complexity, redactions need to be made. And where I actually struggle on this issue is the fact that in many documents, I guess the question really is whose privacy actually are we dealing with in these individual documents? And in many documents, you're dealing with private citizen information, right? Private citizens engage the government all the time, including in situations where they have no choice. That may actually include victims of crimes, right? They didn't have a choice to be a victim, yet they have to engage the government, engage police to seek redress. There are unique privacy interests there, actually, that could be hindered by disclosure. Families that have their kids go to public schools, not really a choice necessarily. You're using the government to educate yourself. You're a private citizen. You have privacy rights with respect to those documents. Public utility customers, right? Privacy interests. You're a private citizen being compelled to engage the government. And so that is actually an area where I struggle with, and I actually think in many of those situations, I think probably the privacy interest very well may trump the public interest in disclosure. The lines that I kind of draw in my brain, for what it's worth, when I'm kind of thinking about the requests I want to make or whether or not I want to litigate something, is maybe where there's a government actor that's claiming some sort of privacy interest, and that's kind of where I maybe draw the line in my brain. Well, it's like, well, wait a second, maybe not. I'm trying to get at something that you maybe did in your official capacity while you were on the job, while you're being paid by the taxpayers. So that's the line that I kind of draw when I'm thinking about privacy. But I want to just reiterate that this is actually a pretty difficult job that government actors need to go through in drawing those lines. And so that just for what it's worth, when I'm doing my work, I'm kind of drawing this public-private distinction, private citizens versus public actors. And I think the privacy interests are fundamentally different on either side of that.
Okay, thank you. All right, one last general question to the group before we take questions from the audience. And we have a couple submitted here, and then we'll open it up to anybody. But I think we have to address the elephant in the room. With this one, the Spanish flu of 1918 was initially downplayed in Western media due to wartime censoring of its severity and impact. I mean, didn't want to give the enemy a leg up on how many soldiers you no longer had. But now, today in 2020, COVID-19 is widely reported upon in cable news and radio, social and digital media, the newspaper. And, I think we've seen how society has changed in just the last week. I noticed tonight, for example, there wasn't a lot of handshaking going on here. I was at a an organization today, a very small organization, 4 people there, and it's a nonprofit. And I was visiting one of my communications interns there and had not met the executive director until today, and nor had I met the other 2 people in the PR marketing department. The 2 women in the PR marketing department said that they would not shake hands because that's not what they were following, the protocol. But the executive director stuck his hand right out. So, you know, I know people have different approaches to this, but, you know, you're in the media, 2 of you are in the legal profession, and Mark, your agency has been very busy now with this. But just throwing it out to the panel, what are your thoughts on the different approach today, 100 years later, that there is all, you know, 24/7 news on this? I mean, we could turn on the television right now and be getting an update on how many deaths and how many cases there have been, and remember to wash your hands. So anybody want to respond to that?
I'll take a swing at it.
Okay.
So it's a real challenge right now to, and you can't right now because of the way it is. It's 24/7 news cycle. We're dealing with social media. You're talking about information overload for a lot of folks. People are really looking to find out, and I think most people are trying to find out where is the clear channel of information that I can rely upon that's credible, instead of, and cut through the chaff and get to the meat of the matter and find out what it is that I can do to protect myself and do what I can to mitigate my risk, reduce my exposure. Government's always been challenged with that. Whether you see it at the federal level or at the state level or at the local level, everybody gets challenged with that. And I can speak from what we're doing at the state level to make sure that that information conduit is clear. And by the governor's direction, we've, through the Director of Homeland Security and Emergency Management, she has taken it full bore and by the reins, and she has spun up the Joint Information Center to make sure that that information conduit is clear directly from the governor's office through the Joint Information Center at Homeland Security and Emergency Management to make sure that the latest and greatest information from Health and Human Services, from Homeland Security and Emergency Management, and from the CDC, for example, is all coming out of one office at the state level. And that was really a clear step in the right direction to make sure that the information that folks have available to them is from one point, one location, and is similar in scope to the messaging they should get across the board when it comes to state government's approach to handling this. Go ahead. No, please go ahead, Dean.
I was just going to say, exactly what Mark's talking about. I was really appreciative to see that email come in about the information center. Sometimes you'll see these bunkers open up and you think, well, it's a little overreaction, but certainly it wasn't anything like this. This was an information center. They had a number in there that news outlets could pass on to the public to call, as well as numbers, phone numbers to be used only by press seeking updates. I haven't called the numbers yet. I just saw the email this morning, I think. But I think that is the ideal way to do it, as opposed to having people not being confused to where to look, turning on TV, getting on social media. It might be interesting or important information they might find. It might be something that's a little bit exaggerated, or like in the case of the Elliott Hospital, people see all these people masked up. They really think the plague, is here. So having an information center like that, I think is critical, and I was really pleased to do that. We in newspaper world like to blame TV for hyping things, whether it's national cable news or, the folks up in Manchester at MUR. But if we all are able to have a resource to go to trust and to get the basic information unvarnished, I think that's a great thing to have.
Well, I'd just like to add that the government is also trying to balance the interests of different organizations, perhaps hospitals where the people are getting tested. And I was so disappointed, I'm glad, but we're a week into this problem in New Hampshire. We had the first case a week ago. Today, they announced a joint effort to get the information out the way it should be gotten out. And after the first case was released, I asked a bunch of questions. The person had returned from Italy, and I think what I would want to know as a reader or as a citizen or as a reporter is, how did they get from Italy back to Grafton County? What bus were they on? Did they take the same plane I took? None of the travel itineraries have been released. Today, I saw a couple of schools were closed because some sibling was on a bus with somebody who tested positive. We don't know what bus or from where. These are details that people need to protect themselves. And I've been, probably the less happy reporter doing this, although we have reason to do this. One of the first individual who contracted COVID-19 that was reported in New Hampshire, Dartmouth-Hitchcock Medical Center stepped up to the plate and said, he works here. And I suppose I can live without a name, but later on I saw it reported in the Valley News that this person was an intern. So this person had contact with other patients. But those parts of the story are a little sketchy, and you only catch them if somebody tips off the reporter. And it's with enough credible information that the paper will run with it. Now, this first person who was tested positive, who the Valley News is reporting was a medical intern at the hospital, he was told to self-isolate. The Department of Public Health in New Hampshire said the guy failed to self-isolate, and he went to a mixer over at White River Junction with some Tuck School of Business people. Now, the state never said Tuck School of Business. We had to get all of that. Half of this we got from the Vermont Department of Public Health, who was giving out a little bit more. So there's some real difference of what we need to know as citizens to protect ourselves. I want to know if I have to just rely on the person who's been found to have this COVID-19, their memory of who they saw that day. Did they run in and get some groceries? Did they do this? From what I understand from the state, these are all people self-isolating at home. Luckily, no one is sick enough that they need to go into the hospital or be cared for at the hospital at this point. And I think there's a lot of information that hasn't come out. I was so dismayed because after a while, they just stop returning your emails if they don't like your questions. Sometimes the state does that. I don't know if you've ever heard of that, but
I have
they
not.
do.
It's not
And I don't mean to
necessarily
say they. Some do, some of the people in the state. So I was dismayed, so I sent an email explaining all of the details we weren't getting to the Health and Human Services Committee for the State Senate. These are people who oversee the Department of Health and Human Services. And now my emails get answered. My questions get answered way more than they were. This is about accountability. We're not trying to make anybody look bad, foolish, good, or bad. That's not my job. I think the state looks great when they give out enough information to keep people healthy and let them do their job. And as I explained to them, why it's town meeting day Tuesday. Why can't we know which towns these people are self-isolating in? Now, Beth Daly with the Department of Health and Human Services has a very good explanation. She says that the HIPAA law, that's the federal privacy law that protects patient confidentiality, also includes geographical information that could expose who the individual is. So I can disagree, but that's their view and that's how they're doing it, and they have that's their reasoning. I have to live with that. But when you're going to go vote at town meeting today and you know that it's somebody in the other county was Rockingham County, it's a very big county, and then we find out that person tested at a hospital in Hillsborough County. There's a lot of potential for screwing up, like the guy that went to the mixer instead of staying home when he was diagnosed with COVID-19. Somebody got COVID-19 from him because he ignored the rules. And what the state did as a result of that was they issued a formal order by law ordering him to stay home, and they're now monitoring him with public health nurses. These are never as simple as they look, these stories. They're much more complicated, but our job is to get as much information to you. All I am as a reporter is a conduit of information. I pass on information to the public. All of you don't have time to, maybe you do, call up the government or go to press conferences or get press releases. I see that as our role, and I think even more so now that I'm in the nonprofit news world, where I see it really as public interest journalism. I'm not trying to scoop anyone. We actually share our stories for a nominal fee and with a lot of other newspapers. And I'll tell you, there's a lot of interest in this. In the last week alone, I looked at our numbers before I came, we had almost 60,000 page views in a week. That's a lot for a small outlet like us. People want to know what's going on, and we try to respond quickly. Sometimes I just put up the government press release if I feel that's the quickest, most efficient way to get the information out. And as I mentioned, with the Elliott Hospital one, I was happy to work in tandem with the nurse, the chief nurse there, and the PR people to make sure we weren't trying to, come across as looking bad, good, or indifferent, but to just tell the truth and get the facts out there.
And that's the role of the journalist.
Yep.
Rick, did you have anything to add?
I think it's not very much. I think this is an enormously difficult and important question. I think it transcends technical issues of the right to know law and so forth. I respect, and I think we all have to respect the privacy interests of individual patients and victims of this kind of illness. On the other hand, it's hard to imagine a more compelling public interest than the interest in knowing enough to keep yourself and your family safe. So I think there are some very strong interests that are colliding here, and I don't envy anybody the task of trying to balance it. I would say this, I'm always a little uncomfortable and antsy about government trying to control the flow of information. In general, I think, information ought to flow freely, and it ought not to be restricted or filtered by government. I do appreciate the fact that there is an effort to provide consistent and reliable information, and that probably requires some kind of centralized system for doing it. And I understand that the importance of doing that so that the citizenry doesn't panic and get confused. But I hope that people like Nancy, and I know this is true of Nancy, but I hope people like Nancy won't stop there and rely solely on what the government is telling them about what's going on here. We have a free press that has a really important job to do, and part of that job, I think, is to go beyond what government is telling us.
We have a saying in the news business, if a public official, be it even a lawyer or a judge or a police officer or the owner of a big company, tells you there's nothing going on here, nothing to see. There is, in fact, something going on and something to see, 9 times out of 10. But, just quickly on that subject, I think the privacy, I think we all agree here that privacy to an extent, 100, 200 years ago, they'd find somebody that was sick and, was transmitting a disease, and they'd go seek them out and kill them. Obviously it's hopefully not going to happen today, but by the same token, you don't want to put those people in a situation where they've got to deal with, being avoided by all kinds of people and everything. But we, at the same time, should be able to get the information out that would help protect people, like we've all said up here. And I think that center they set up will hopefully do that.
Okay, thank you. We have some questions from the audience, and so I think I'll probably try to address them to the appropriate individual and just ask for, sake of time, that you keep your response to about 2 minutes, and then we can open it up to the general audience. But I think this probably would be for Rick or Gilles. As a union steward rep representing, let me start over. As a union steward representing CCS&H Community College System of New Hampshire staff, can I ask the system for information like salaries? And what am I to do when they say no, or if they say no?
Anybody can ask the college for salary information, and there aren't very many clear answers under the right to know law, but that's one.
Okay.
You get public employee salaries are public.
Okay.
You don't get it because you're a staff member, you get it because you're a member of the public.
And you can get it linked to name,
Okay.
usually at least, so.
Yeah, okay. So at the local level as well as the state level then?
Yes.
Okay.
Yes.
Correct.
Okay. This is for Nancy. Do you think news blogs like Granite Grok serve an important role in covering the news?
I don't know how many of you read Granite Grok. I haven't, I once in a while will check it out. It's a partisan blog. It's not a news, I don't think it pretends to be a news outlet. But I think more and more of that is happening today with people trying to find written material, news or quote news that aligns with their own personal beliefs. I believe it's a conservative blog, but I haven't really studied, is it? Yeah. And people put their opinions up there. I think it's wonderful that people get their opinions out there. I just don't want to have it confused with news, It's not the same as news. And I don't think it tries to pretend that it is. And I know for our website, we take no position on any issue, but we welcome diverse ideas and opinions. So if people send us their opinion on an issue and it's not just name calling or finger pointing, I put it up, but I put opinion : so people can try to figure out the difference. I think as fewer and fewer people are reading their local newspaper, there's been a bit of a blur between what is editorial, what is an editorial, what is an editorial cartoon. I have people that think we're unfair because we have a left-leaning editorial cartoon. You know what? A fair and balanced cartoon would be so dull, I wouldn't want to publish it. But that's my 2 minutes.
Okay, thank you. And last question, should government answer a right-to-know request which seeks documents showing how false information has ended up in state contracts concerning, I believe it's public lands? So maybe Rick or Gilles?
I guess the only way I can answer that is to say that of course they should answer that if the request is made in a way that you can respond to and understand. Mark was mentioning, the struggle sometimes to figure out what is it exactly people are looking for. That's sort of the threshold question. And on that one, it seems to me the threshold question is what exactly are you looking for that some public agency or official can then go try to locate?
I think the state can actually, in this particular instance, and I don't want to speak out of turn
Yeah,
at
no,
the time,
it's fine.
but I think the state can actually push that back and say, I think you need to refine this a little bit more, be a little bit more
I actually agree with that.
specific.
Okay, thank you. All right, I'd like to open it up to the audience right now. Yes, sir.
Yeah, sure. Hi. Yeah, first, I commend you for the panel, for all protecting the First Amendment, free and vibrant press. And we can hear him on TV. We can't hear you if you don't use the microphone. Oh, maybe she could.
Thank you.
Yeah, thank you. So I wanted to commend you all, as I said, for protecting the First Amendment and the free and vibrant press. And I appreciate the difficult decisions that you talked about, victim privacy and health safety. Dean, I'm a reader and I'm a subscriber, so this isn't meant to be an attack, but it may be true that right to know is getting better in journalism for the professionals who are used to filing for right to knows. But my recent observations as an individual, that's not my perception. I'm speaking specifically of the city of Nashua with respect to the tax assessing issues. Now, that's not my opinion. That's the city stated that they admitted to the issues in their March 2019 report. A lot of credit goes to the two ladies that are sitting there. I'm a mere, occasional dilettante, having gone to only a couple of Board of Assessment and Board of Alderman meetings. But yeah, we often hear that's a private personnel matter, the few times I've gone. And again, credit to them for being willing to spend the money, to file suit and taking the time to do that. I can't think, and not only, it seems like the tactic for the city is just to wear down private individuals, make them take the time, make them spend the money, and also malign them. And again, I think it's well overdue that they get their credit for what they have done. And I can't think of something, and again, often when I say malign, it's usually delivered well. It's, nothing is going on. We put people in place, who are going to solve the issue, and don't worry about it. It'll all get sorted. Don't ask any more questions is basically the line from the city. I can't think of, if you think about how our country was founded, around taxation and fairness, this really is an important issue, and anyone who's seen any of the work that these ladies have put out would say, hey, there's something going on, even though the city just keeps repeating, no, there's nothing going on. Thanks.
You got all that onto that envelope? I know one of the ladies to whom you're referring, and I'll say this, I agree 100%. She's a terrific example of citizen reporter, if you will. But by delving into this whole issue to which we're referring, it's, for those who don't know, it's the tax assessing process in Nashua that has had some changes. The changes that have been made there, some of the direct result of what the work she's done. And we in this business certainly applaud that, and we appreciate that. Our resources, I don't want to sound like I'm whining here, but to get more detail would be a great thing for us to do. At this time, our resources at the paper are limited, and that is another reason why we appreciate citizens who take it upon themselves and share that information with us. I think it's extremely important to get that information out there, and to hold those people accountable. If we had a little bit more resources like we did at one time, we certainly would have somebody, if not full-time, but very close to it on the issue, reporting on that issue all the time. As it is, we try to get information that the results of a meeting or the results of some discussion about a particular issue and report as best we can on it. Now that it's in the legal system, I was very pleased to see that, because that gives us another avenue from which to report. And I'm not saying that we just, take the case file and quote from it, but it's a great resource to have, and it has both sides. The responses today, there was a hearing in a case. The city which is the defendant, made a motion for a continuance, and it was granted by the judge. That's not unusual, especially in civil cases, but so we're on that side. We appreciate that, and we certainly will be paying as much attention going forward as we can to it.
Okay,
You know,
thank you.
could I just add to that?
Sure.
My hat's off to you, filing right-to-know complaints and lawsuits, they get expensive. I'm only vaguely familiar with this particular case, but it sounds like something that should go forward and that you're doing that. But I know that from talking with other citizens around the state, once they start filing right-to-know complaints and civil actions and court cases, they often get ostracized in their community. There's a lot of bad blood, and it's really can get very ugly. So my hat's off to you, and I think it's a really interesting case. I'm going to start paying attention to it more now. But David Saad, Right to Know New Hampshire, I love that group because it's grassroots. They help. Perhaps somebody in one part of the state has had a similar issue to what you're dealing with, and I think they meet once a month, and not that reporters shouldn't be doing our due diligence as well. We should be, and we are doing our best.
Thank you. All right, yes, ma'am.
Or you can.
Thank you. I'm from Nashua, and I've held public office there, and I know our cameras are rolling, and so I want to reiterate what you people have said. You must be Lori. Are you Lori? Congratulations. Thank you for what you've done, and I hope it does not end there. I think a lot of us who have dealt with the city, we know that there have been issues there and that have not been addressed. And I applaud you. And so I want to be recorded, and I hope more people from Nashua will start to follow this. Thanks to Nancy and to Dean and all of you folks. It's an interesting story. So please do follow it, and thank you very much for what you've done.
Thank you.
Hi, Lori Ortolano. Couple specific questions, and I have been I'm a member of the New Hampshire Right to Know Coalition, and David has helped me out, and I was able to go up for some of the hearings on the proposals for RTK changes that were pretty directly written because of my requests and testify up there with the Judicial Committee. So that was good. And it was good for me to do, and it was a great experience. So a couple specific things I've tried to get at with the city that aren't part of my RTK suit that's out there now. One of them was a report that was commissioned by the city with our taxpayer money to have an attorney look into whether we had some mileage fraud issues going on with reimbursements for mileage. And we paid them maybe, I don't know, $15,000, $20,000. They came in, they did a report. It took, I figured through a right to know that the report was actually finished sometime at the end of July because it was just nothing said about it. So I went in and I asked for the financial records for the payout to this lawyer. And the last bill was submitted at the end of July, so the report had been done. So then I asked if we could get a copy of the report, redacted or otherwise. It was outright refused, fully unavailable. And part of me wonders if some of that could be available. I suspect, it involved an employee, so you have an issue there. But the secondary thing is, I suspect a lot of the report targeted the fact that there was ineffective management going on in city government to deal with these documenting and recording issues for mileage and what was happening. So that's totally off the table. We're unable to see and look at that, and that to me is a record that would be of interest to us. And the other item was a set of minutes that got sealed that I went in and happened to find a property record card that had a really interesting assessment. And the practice of how the assessment was done was really curious to me. property record cards actually document who the assessor was who did the assessment. That's all public. And supposedly, the process of assessing is an open process whereby any assessor should be able to value, defend their work. That's an IAAO, the International Association of Assessing Officials guideline that's highlighted by the Department of Revenue. So I was publicly asking about the process of the assessing, and the legal team said, hey, we got to go in non-public. We're going to close this down, we're going into non-public. And I wasn't actually addressing any individual by name, I was speaking general. So we ended up in non-public. The whole conversation on the process of the assessment was non-public, and then the minutes got sealed. And so I tried to go after them to say, hey, unseal these minutes. This is how assessing's done. We should all be able to understand it. And they refused, and those minutes stay locked now. And it's just interesting because I didn't go after those situations yet, but they are in the back of my mind as some that I want to dig at because they concern me. Thank you.
I just have a question then. With respect to the report, what exemption is being relied upon? Is it internal personnel practices? Is it, okay. Any others that you're aware of that are being relied upon? Okay, so, all right, so your case, and that's directly at issue in your lawsuit that you had a hearing today on? Okay. Yeah, so the internal personnel practice issue that you're dealing with in your case, we, to be frank, don't know what the law is right now. And it's going to be, I don't know if that came up, but, you know, that's directly the issue that the New Hampshire Supreme Court is going to decide, the scope of that exemption. And we'll know a lot more after those cases as to how it applies in your case, our cases, the Concord School District case. So that's why what I was asking. As to the, so they said the confidential exemption is also 91A 5, Roman numeral 4, again, my favorite or not so favorite. So again, you know, the analysis there is, even if they can make a showing that it's confidential, there's a second step of the analysis, public interest in disclosure balanced against any privacy interest. So that's the argument that you're going to want to make. Number one, it's not confidential if you have a good faith basis to argue that. But even if it is, your argument is there's a strong public interest in disclosure, the privacy interests in non-disclosure are minimal. Those would be the arguments, at least, to the extent they apply.
Okay, thank you. And yes, ma'am, back there. You, yeah. And that'll be our last question for the evening.
Hi, my name is Patricia Rodriguez, and I live in Westmoreland, New Hampshire. And I've had a very long-standing dispute with the state of New Hampshire concerning my land and public lands that abut it immediately along one side. And I was the one who presented the case about requesting information about false information in state contracts. And I did get very specific with my requests. And I actually have had Harriet Cady, co-founder of Right to Know New Hampshire, assisting me as well. Basically, I was told that the state didn't have to release draft information between the beginning of the application of the state contracts to the very end product, even though the false information in them said that something that is part of my deeded 1848 historic access to the public lands known as the historic Cheshire Rail Trail doesn't exist when it does exist. And in fact, in 2016, I got New Hampshire DOT to do a survey proving that this structure, part of my access rights, does still exist. Yet the contracts still remain as they did. And because of that, I can't sell my property to leave and get out. And yes, I have been ostracized horribly. And it's cost me money. And in a related case, recently, I paid the court fees to go to Superior Court because the state and the town next to me made another decision without informing me of the use of this historic access. That's false. And within that case, in Cheshire County Superior Court, after a decision was made, the town, I actually border the town of Walpole. One of my property lines is the town line, although nobody really knows where that is. And that town is the town I filed the lawsuit against, Walpole, New Hampshire. And after we were issued a decision, the town actually submitted an affidavit trying to defend their own employees' erasure of meeting minutes before they were allowed to be erased. They outright blatantly lied. And the judge's decision didn't address that right-to-know violation amongst several others. And Harriet Cady was supposed to help me file in Supreme Court after that, but she became ill, and I was ill, and it was Christmas time, and couldn't get anybody else to help. Never mind all the money it's costing me. You said time? You said, who has time to go to meetings? Who has time? I've lost a lot of money and time trying to defend my home that I can't sell and get out because I don't want to live there anymore, and I can't keep living there because the purpose of this access is to put in an 18-acre, 150-foot deep, coming within 340 feet of my home, all subterranean bedrock blasted quarry that's going to run me out of my home and off my land. And of course, it's DOT, and it's DES, and it's the New Hampshire Division of Historic Resources that doesn't acknowledge the historic infrastructure that are involved in this whole degradation of the public's historic Cheshire Rail Trail that was paid for with over $1 million of our money to buy that rail trail for the people. You know, I'm just beyond hope that equality and justice for all exists. And all of this was done behind my back without my knowledge. And my name is Patricia Rodriguez, and yes, I think that has a factor. People will say, oh, no, 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 but that's just my own personal feeling. Anyway.
Thank you.
I love living here since 1996, but I can't wait to get out.
Thank you.
Any response from the panel?
You know, I think when citizens have a right to know complaint, it's really can be very overwhelming, and it's difficult, and hats off to you for continuing the fight. Are we getting close to the end today?
We are.
I would just like to say, besides this terrific panel here, we have Justin Silverman from the New England First Amendment Coalition, who also co-sponsored with the Nashua Community College. And I just wanted to not put you on the spot, but ask you a quick question. Do you see some of these same issues all over New England? I know you came up from Rhode Island today. Are we unique?
In a lot of ways, no. We find very similar issues throughout the region, while obviously a lot of what was discussed today is very local in context. The specific challenges that come with the right to know law are often found in various freedom of information laws throughout New England. So I would also like to thank all of you for being here and tackling these challenges and really trying to address the citizens' right to know. It's a very important right and freedom that we all have that needs to be protected. And I look forward to speaking to many of you once we wrap up here. Thank you.
Thank you.
Can I follow up on that for just a second? Because Justin left out something important that needs to be said. There's been a lot of mention today of the Right to Know New Hampshire organization with David Side, does a wonderful job. Justin Silverman is one of the most energetic, committed, dedicated advocates for the First Amendment that you will ever find. The New England First Amendment Coalition, and I'll disclose that I'm a board member, so I have a stake in it, but is a phenomenal, effective organization. Justin does an incredible job every day. Go on the website, take a look at what we do. It's an amazing group. It is New England-wide. It's not dedicated to New Hampshire, obviously, but that's an organization. If you have any interest in these issues, that's an organization that should be on your radar.
Actually, that's how I found Rick Gagliuso with one of my right-to-know arguments. Probably 5 years ago, I contacted the New England First Amendment Coalition, and they have attorneys from all over New England who help as best they all can, and it's just a wonderful resource, so thank you.
Okay. Well, I'd like to thank our panelists for their expertise. I think yes?
Thank you. Thank you all.
They answered a lot of our questions. I'd like to give a shout out to my colleague in the back, Tina Forbes. She is our campus communications specialist, and she and Nancy organized this event, so.
Don't forget that Tina's also a former Telegraph staff reporter, back when we filled all our chairs.
Yeah, that's right, yeah. And thank you for coming, and thank you for your interest and your commitment to transparent government and our citizens' right to the right to know as well. So, stay healthy. Have a
Thank you.
good evening. Thank you, Sally.
Every day I just